my lords and my lady, just to sort of highlight two things I've dropped off on, or I've had put up on your desk, and I will come to them. There are two authorities, Odolola, which my lady made reference to, and the subsequent judgment of the Supreme Court in Alvey, which I made reference to, and I'll come on to those in a moment.
Very good, thank you.
When the court rose, I was making submissions about the Refugee Convention, and the basic reason for doing that was because it is quite clearly the origin of the language that is used in all the subsequent provisions. It is the earliest provision that adopts this language, and it does so in the context of Article 33, which is, in one sense, the fundamental and most important provision. It's certainly a fundamental provision of the Refugee Convention, because it's the provision that gives rise to the most important right. It's the protection against being returned to the country where you risk persecution, essentially. And Article 33 is at page 39. And just to make good the point I've already made, sub-article 1 is that basic right that really we would say is at the heart of the Refugee Convention, which is the right to protection, effectively, the right to be protected against refoulement. And article 2, sub-article 2 is a carve-out from that, which applies in two circumstances. The first is where there is a danger to national security, and the second is where there is a conviction for a particularly serious crime and a danger to the community. Now, the structure of that article in our submission is an important starting point, because that language in our submission, when it's used in that context, and this is consistent with the approach of UNHCR that I'll come to, cannot mean, in our submission, that any danger, no matter how limited, can justify refoulement. In our submission, as a matter of straightforward interpretation, adopting the approach in Article 31 of the Vienna Convention, which requires essentially the interpretation of conventions in light of their object and purpose. I won't take you to Article 31, but it's at page 41 of the authorities. Given that the primary purpose is protection, in our submission, it must be the case that the danger essentially is sufficiently grave or sufficiently serious that it justifies the denial of protection. And that's why, although there's no reference to proportionality, and in one sense, what's in issue in this case isn't classical proportionality. It's not balancing the interests of the individual against the interests of the state, the sort of Article 8.2 balance that the court will be very familiar with under the European Convention on Human Rights. What must be implicit in this scheme is that if, for example, risk can be easily managed so that there is no threat, it must be implicit that's not sufficient, because the whole scheme of this must implicitly require a risk that is sufficiently high to justify that denial of basic rights. Now, that submission, which we submit, is consistent with the structure of Article 33, finds support, essentially, in the guidance that's been issued by UNHCR. And that's been found in found in 3 places, 2 within the authorities bundle. If you look at, if you go to 651 of the authorities bundle, you'll see the guidance note on both extradition and international refugee protection. And at 654, looking at Article 33.2, Article 14, paragraph 14, Roman 1, makes the point essentially that the danger must be very serious and must constitute a threat to national security. That's relevant in relation to our first ground raised in the respondent's notice. But separately to that, it indicates that there needs to be, at paragraph 15, there needs to be a rational connection between the removal of the refugee and the elimination of the danger. And based on that, it adopts the approach of last possible resort. It footnotes that, which may, to some extent, go to the point I think my Lord Justice Mayles asked about how does this fit in. It footnotes that with an explanation that if less serious measures would be sufficient to remove the threat, reform cannot be justified. In other words, it seems to be saying that danger in Article 33.2 has to be assessed as meaning danger after the state has taken steps that are open to it. I emphasise, though, the fact that the guidance uses the words last possible resort. Although the European Court of Justice doesn't explain where it gets, as far as I can see, that phrase last possible resort, it is striking that it is a phrase that has been used earlier by UNHCR, given its particular role.
They say last possible resort or just last resort in T? I can't remember.
I can't remember. I'd need to check.
I think it just might be last resort.
Last resort, but it's.
I might be wrong.
You may be right, my lady.
No, it is last resort.
But it's still
71.
The point I'm making is it's still effectively the same, and it's expressed in very similar terms.
Forgive me, where is the reference to last resort here?
Paragraph 15, second sentence. After explaining, essentially, there needs to be a rational connection between removal and elimination of danger.
Can I just understand what's been done here is imposing some quite significant gloss on the words of the convention itself, such that the convention uses the word danger, and then it says the danger must be very serious. So what is the legal analysis here? The Vienna Convention says the starting point is the words used.
Well, it's the words used in context, essentially, with considering in particular the objective of the measure.
And you only look at travaux or whatever to confirm the meaning, don't you? Unless there's ambiguity.
Well, except, and this is where perhaps one goes further with UNHCR material, and I was going to come on to this. In AAA, the Supreme Court made it clear that because of the structure of the Refugee Convention, UNHCR has a particular role to play in the interpretation of convention provisions. And I'll come to that. And this isn't quite the same as, for example, looking at travaux in our submission. It's UNHCR are entrusted essentially with the interpretation, and so that's why their guidance. And on the face of it, we would submit this is guidance which isn't, for example, aspirational. It isn't encouraging states to go beyond the convention. It is, on the face of it, because you particularly when you start with paragraph 13, which is where it talks about what the exceptions are to 33.2, and then it talks about the application of this provision. What it is seeking to do is interpret that provision, and it does so essentially from the starting point, which is where I was starting from. Article 33.1 provides a key protection, so Article 33.2 needs to be interpreted in light of that, and it needs to be interpreted narrowly. And you see that in particular, for example, in paragraph 15, where the first sentence is a restrictive application.
So this isn't travaux préparatoires, it's ex post facto interpretation.
It's ex post facto interpretation by UNHCR, and I emphasise by UNHCR, given...
I can't remember, but to the extent that SIAC referred to UNHCR materials, my feeling is the Commission ended up saying it wasn't influenced by those, or they weren't relevant. Am I right about that? Or have I got
I'm
that
not
wrong?
sure that's right. I'm not sure, as they refer to it, I'm not sure they specifically... but our point is that which obviously you've raised, hopefully appropriately, through the skeleton argument, is that when you look at what was said in T, T isn't a freestanding, in one sense, sort of sudden pronouncement as to the approach to this Article 24. It is in the context, essentially, of what's gone before, and what's gone before is firstly the Refugee Convention, Article 33, and then secondly the guidance that's been issued by UNHCR. And that guidance we would submit is entirely consistent with T. Then the second document you have is a paper, essentially, headed Application of Article 33.2. So clearly, again, about how Article 33.2 operates.
Sorry, where are we looking
Sorry,
at?
it's the next tab. It's page 658. It starts.
Oh yes, thank you.
And it's dated April 2014. And it's at page 658 under the heading Application of Article 33.2 must be necessary and proportionate. And you'll see Roman 2 in particular. Effectively repeats what's already been said. But so UNHCR seem to adopt a fairly consistent approach. There is also reference in the SIAC determination, I won't take you to it, paragraph 174, to a UNHCR letter, even more recent, which again talks about the need to interpret Article 33.2 restrictively.
How is the Secretary of State supposed to balance the risk of harm to the wanted person against the danger to the host country? So does he have to form a view on how likely it is that the refugee will be killed or put in prison if they're sent back to their home country on the one hand, against how likely it is that they'll plant a bomb somewhere? And what's the exercise they're supposed to do?
Well, partly that nobody's argued, in fact, for that the exercise my Lord is putting to me.
Well, I was just wondering what it means, because on the face of it, it doesn't seem to mean anything. Really.
Well, what it means in my submission is this: Article 33(1) is there to protect someone against serious violations of their human rights. Because of the statutory scheme, no one's suggesting you need to, there's a scale, so some people are at higher risk of that, some people are low, you need to take account of that. So you discount that, and that's not what SIAC did. It didn't sort of say, well, this is someone who's particularly at high risk or anything like that. That's where there would have potentially been problems with the legislative scheme, I accept that. However, on the, there obviously in our submission are degrees of risk, and there are degrees of risk in part because some risks may be easier to manage than others. And obviously within the UK there are a range of steps that can be and are taken to manage against threats. So perhaps at the bottom end of the spectrum there is maybe some forms of surveillance. There are things like TPIMs. I can never remember what TPIMs are. What used to be control orders.
Yes, quite. They're much easier to understand.
Yes, I think it's terrorism prevention and interim measures or something, but I can't remember. I never remember exactly what the I stands for, is my problem. But there are a range of things that can be done and that potentially are clearly intended to manage risk. And what in my submission UNHCR are saying is simply, it's not enough for the Secretary of State to say, well, there's a risk here, that's it. We don't need to look at, for example, how it can be managed, because that could cause a very low risk essentially to be relied upon in circumstances where what's being denied is a fundamental right. The Secretary of State has to go through, I would submit, applying the approach of UNHCR, the exercise of saying, well, actually, I'm denying someone fundamental rights. As a result, I need to consider if the risk is sufficient that it justifies that, and in taking account of that, I need to think about what else I can do to manage that risk. And that's an exercise in my submission that's not that difficult to do, I would have thought. There's certainly no evidence it's difficult to do, in part because that's the sort of thing the Secretary of State needs to do anyway. Going back, or the security services need to do anyway. I mean, they have to make decisions, for example, about whether the level of risk justifies surveillance. Because the Secretary of State is obviously not surveilling everyone in the country. So they have to make decisions about whether the level of risk justifies that. They have to make decisions about whether the level of risk justifies a TPIM.
But the Commission itself didn't seem to think this was a terribly easy thing to do, because in paragraph 194, which I think my laws are already drawing attention to, it said, following the Secretary of Statement's balance of degree of danger to national security, open brackets, assuming that it is possible to assess it in the circumstances of an individual case.
Well,
so the Commission itself doesn't seem to have thought this was an easy thing to do, necessarily.
It's unclear. I have to say, it's slightly unclear what those the words in brackets mean, and it's in my submission. It's not obvious why the level of risk can't be assessed, because, as I've already indicated, that certainly, as a matter of domestic law, one assumes that happens all the time. That there's been.
I mean, the Secretary of State doesn't have a Geiger counter that goes, you know, level 1, level 2, level 3, level 4, level 5. This is all a matter of assessment and judgment, isn't it?
Well, it is, but that's, in one sense, why, if the Secretary of State had come forward and said, well, I recognised that what was an issue here was the Article 33(2) test. As a result, it's a test that applies when someone is denied fundamental rights. In light of that, I've looked at that. I've looked at what steps can be taken to manage risk. In my conclusion, they're not sufficient. And that, if you'd done that, certainly applying the approach of Begum, it might well be very difficult to test, to challenge that. I know our ground 2 sort of raises a slightly, it suggests Begum may not apply in that context. But if we're right about ground 1, Secretary of State's ground 1, then because that does involve a balancing exercise, we would recognise our arguments about Begum potentially fall away, because then you are in a territory where it's very much a question, territory where it's very much for the Secretary of State to manage risk. The other point I'd make about that, as I'm thinking about it, of course, is that because all that happened in this case ultimately was revocation, and that's fundamentally what's in issue in this case, that doesn't imply that the individual is being removed from the country. So the Secretary of State presumably does still have to, on the facts of a case where revocation is an issue, work out the level of danger and work out what steps will be taken to manage it.
Could I ask you this? Going back to the guidance,
Yeah.
At page 654, where it's analysing the security of the country exception, it has footnote 15, where it is referring to commentary which says that, generally speaking, security of the country exception may be invoked as acts of a rather serious nature, endangering directly or indirectly the constitution, government, and territorial integrity, independence, or external peace of the country. Now, if it's determined that somebody poses a danger to those matters, constitution, government, territorial integrity, etc., one would have thought the balancing exercise would be pretty clear cut.
But except, and that's one of the reasons why, in one sense, that what also may be important is the footnote 17, because footnote 17, which is the one I drew attention to, as I understand that, is saying that what you're looking at is the danger after you've taken account of measures that may be taken, that may be reasonable to manage the risk. So going back to my lord asked me the question about the sorts of conduct that are an issue. My point in response to that is that on SIAC's approach, the first question in one sense is there a danger of that after steps have been taken to manage it, or is there a sufficient danger of that after?
Well, that's a different question, isn't it?
Yeah.
We're working on the assumption. The assumption at the moment is that the Secretary of State is right in categorising D8 as a danger to national security. And we're now looking at whether or not that has to be put into some sort of proportionality balancing exercise. I think that's a different question to whether or not, when you decide whether somebody's a danger, you consider in that context what other steps could be taken.
Well, I'm not sure it is, my lord, with respect, in the sense that if you look at the approach of the Secretary of SIAC, the SIAC's on the facts of this case, SIAC says Secretary of State concluded that there was a risk without conducting the balancing exercise. Now, what it seemed to mean by that is no consideration had been given to those steps to manage. And that, in my submission, is quite an important starting point, because what the balancing exercise that is described here is simply, in one sense, that it's not what I might describe as a traditional balancing exercise in human rights. It's simply looking at the extent to which measures that might be taken are in fact reasonable to take. What it's seeking to do in my submission is qualify what might be seen as a sort of absolute approach, which is if there are any measures that can be taken that manage risk, that's an answer to that's a reason not to revoke. What SIAC, perhaps unsurprisingly, is doing, and it's the submission I made before lunch, is recognising that you have to recognise that steps have to be practical, reasonable, cost effective, essentially.
But all the footnote 17 is saying is if you can, it takes the threat as assessed by the state as the premise, and it says if other measures, if less serious measures would be sufficient to remove the threat posed by the refugee, then refoulement can't be justified. But it's not saying that the potential existence of other measures is a way of measuring whether or not there's a threat. The threat's taken as a given, isn't it?
Well, what I would submit it's doing is it's recognising, because it's linking it with refoulement, it's recognising that the ultimate question is the threat after steps have potentially been taken to manage that risk.
But that's not what footnote 7 says.
Well,
What footnote 17 is saying is that if other measures be sufficient to remove the threat, then you can't justify refoulement, which is a different question.
well, except what I'm the reason I'm making the submission I am is it then goes on to it relies on Article 33.2 in relation to that, and it relies on Article 33.2, which obviously references danger, and says it can't be justified. And when you read that footnote in my submission with Article 33.2, the way in which that seems to fit into Article 33.2, we would submit, is because it means that if the threat can be managed, essentially, there's not the danger required by Article 33.2. That's how I read that footnote. I mean, I may be right, I may be wrong, but that's...
So if the threat can be managed, there is no threat.
There is no threat for the purposes of Article 33.2.
Okay.
I mean, in one sense, I was listening to the questions that my learned friend was asked about that this morning, and I have to say, in one sense, I'm not sure how much that issue assists, in the sense that whether it feeds in at the stage I've suggested it does, reflecting that footnote, we would say, or whether it feeds in because ultimately giving Article 33 as a whole a purposive construction, risks that can be managed rather can't justify that denial of fundamental rights. It may not matter, because either way you end up with the same conclusion from the overall construction of Article 33, which is not surprising, which is there needs to be a risk that is sufficiently high and can't be managed in order to justify denial of fundamental rights.
Well, it depends what you mean, what's included in the formula fundamental rights.
Well, at the moment, I'm just talking, my lady, about Article 33, which is, we say, is a starting point, because it's where it's the origin of the provisions that then follow. In the context of Article 33, Article 33.2 is clearly denying a fundamental right, because the fundamental right is Article 33.1, which is the protection against serious ill treatment as defined in Article 33.1. And that's
it might be clearer if you just referred to the thing that's an issue, which is, in short, protection from refoulement.
Yes, sorry. But that's the fundamental right I'm referring to, my lady.
Yes, all right, that's helpful, thank you.
I mentioned earlier, in terms, because I think it was my Lord Justice Males asked me about the status of this. Can I just take you to AAA at page 291? You've seen it for another purpose. Now, except, to put this in context, this was a direction that the Supreme Court gave itself in the context of factual evidence at UNHCR, but it's clear it is not restricted to that not least because of the second sentence in paragraph 65. I mean, what paragraph 65 draws attention, and this goes to the point I made earlier about the particular status of UNHCR, draws attention to the fact that the General Assembly has entrusted UNHCR with the supervision of the interpretation of the Refugee Convention. It's under that function in our submission that guidance such as that you've seen is produced. Draws attention to Article 35 of the Refugee Convention, and then says this: reflecting those circumstances, it's well established that UNHCR's guidance concerning the interpretation and application of the Refugee Convention should be accorded considerable weight. It goes on to say that the accumulated and unrivaled expertise of this organisation, experience of working with governments throughout the world, development, promotion and enforcement of procedures of high standard and consistent decision-making in the field of refugee status determinations must invest its decisions with considerable authority.
Although the particular aspect of UNHCR's opinion, which was in issue in that case, concerned the factual situation in Rwanda, didn't it?
It did.
Rather than, as it were, in the abstract, the meaning of some provision of the convention.
It did, but you see, that's why I emphasised in paragraph 65, second sentence refers to interpretation.
I accept that.
Fourth sentence does.
Yep.
The other point that I'd make is, and it goes back, I can't remember, one of my lords, I don't think it was my lady, one of my lords asked me the question about Article 31 of the Vienna Convention. We've drawn attention to our skeleton argument. It's not in the authorities bundle because I understand there's no dispute about it. But it's paragraph 13 of our skeleton argument, the judgment in AFSAR, and in particular the principle that the Refugee Convention needs to be given a purposive construction consistent with its humanitarian purpose. And that, we submit, is consistent essentially with the approach that's been adopted by UNHCR.
Well, it's really Article 32 of the Vienna Convention that we'd be considering, wouldn't we? Because Article 31 says that you interpret a treaty in good faith in accordance with its ordinary meaning to be given to the terms of the treaty in their context, in the light of its object and purpose. And then it's 32, which is supplementary means of interpretation.
But just to go back, the reason why I started started with referencing Article 31 is it does talk about. I think I may have used the shorthand context, but actually the language of Article 31.1 is in light of its objects and purposes. That's where AFSAR comes from, because it clearly is a humanitarian. Its purposes are clearly humanitarian. They are to provide protection to those in need of protection, subject to some carve-outs. And all the point I'm making is UNHCR. How does UNHCR fit in? Well, firstly, in one sense, we would submit it, even ignoring its particular status, is what it is doing is trying to interpret, in the guidance I've taken you to, the Article 33.2 in a purposive approach. It's looking at it in the context of a departure from one of the key provisions of the convention, which is the provision of protection. How does it also fit in? We would submit it fits in, for example, under 32 sorry, under 31(3)(a) and B, because essentially there is agreement, such as demonstrated by the approach of the UN General Assembly, that UNHCR will be relevant to its interpretation, or will give guidance as to its interpretation.
Okay, but the UNHCR guidance isn't a subsequent agreement between the parties.
No, the subsequent agreement is the UN General Assembly resolution indicating that UNHCR should have a particular role in the interpretation, which is what was referred to in AAA. That's what I was referring to as subsequent agreement. It's either subsequent agreement or subsequent practice that states essentially regard UNHCR as providing a guide that has to be given.
But it has to be the parties to the convention, doesn't it?
Yes, but I don't think there's any reason to believe that. Yes, it's UN General Assembly, but that obviously, in one sense, is an indication of the views of the the member states of the UN.
But they're not necessarily the parties, because loads and loads of members of the UN haven't signed up to the Refugee Convention, e.g. Russia.
That's true, but equally many have. But I'm slightly concerned about going too far down this route, because obviously AAA is clear and is applying earlier authority to similar effect from the highest order, particularly about interpretation. And so quite how that fits in with Article 31 may not be, maybe a slightly arid debate in one sense with respect to the court, in the sense that there's no basis in my submission for not applying the approach. And that's all I'm arguing for. I'm not arguing for more than was said in AAA.
So what did the Commission make of the materials from the UNHCR?
The Commission's, I think I've made reference. It merely says, and I think this is the reference my lady made, if you go to para, it deals with it, a couple of points. It deals with it, firstly at para 174, which is not the actual material you've got, which is more detailed. It's dealing with a letter which sort of followed on, which sort of set out in summary. It's not entirely clear. It notes that.
When it refers to al-Suri.
It follows. It then goes on. So that seems to be the context in which it considers some of the other materials. It then goes on to an issue which had been raised and is raised by our cross-appeal ground 1, which is a different issue to the issue it finally decides. At para 184, it considers the issue essentially whether danger equals serious danger. And that's where my lady raised the question of whether or not it rejected UNHCR.
Yeah.
That's 189. It rejects that in that context. It rejects the view of UNHCR in that context.
Right. So where does it reject that?
Sorry, 189? So it rejects the view of UNHCR that danger means serious danger. It doesn't, on the face of it, I don't think, a learning friend may correct me if I'm wrong, it doesn't deal with UNHCR at all in relation to its conclusions essentially about needing to assess the extent to which risk can be managed. And the passages of the guidance I've taken you to make it clear that UNHCR's views on that are separate from, albeit based on the same basic point, which is you've got to give Article 33 to a restrictive meaning, but they are separate to this conclusion about how risk has to mean very serious risk.
Right. So in paragraph 184, the Commission identified 2 points from the UNHCR. In paragraph 189, it dealt expressly with one of them, but then
Yes.
it finished the final sentence of 189. Overall, the views of the UNHCR do not provide independent support for D8's case. So they seem to be rejecting all of the submissions based on both submissions,
Well,
which are according to money, or have I got that wrong?
I have to say I read this, and maybe I'm wrong, because of what precedes that in paragraph 189, as being a reference essentially to this issue of danger or serious danger, because that's what it was specifically being considered in that's what was being considered in EN Serbia. The other thing that it may be considering, and it's not entirely clear, is that where it talks about balancing exercise, given that what follows at 185, it may be talking about the sort of balance that it was prohibited by section 34, which it recognises is not the issue in T. What it doesn't appear to be doing, and obviously I didn't argue the case, I'm not entirely sure how it was argued, but what it doesn't seem to be doing is recognising that UNHCR, it doesn't seem to be engaging with the fact that UNHCR is talking about the last resort test.
Right.
But obviously, in one sense, at this level, in certainly my submission, I'm entitled to point to that as being supportive of the approach in T. Now, so far, I've addressed you simply about the Refugee Convention. Unless there's any more questions about that, I was going to move on to EU law. And EU law in our submission, in the form of the Qualification Directive, seeks to give effect to, it may in some respects go further than, but it certainly seeks to give effect to the Refugee Convention and not least because if you go to page 26 of the authorities bundle, you'll see that preamble 3 talks about the Geneva Convention being the cornerstone of the international legal regime. Now, I accept, there's no dispute about this, it's obviously impossible to dispute, that the provision particularly dealing with revocation is Article 14. And as I say, revocation is not a concept found in the Refugee Convention itself. I accept that for the reasons I already indicated. The Refugee Convention is structured differently in that it doesn't include an express obligation to grant status, unlike the Qualification Directive and unlike domestic law. It simply provides protection against refoulement. However, it is striking, and in our submission, no coincidence, that the language used is the language of Article 14.4a. Is the language of Article 33.2. The language used in Article 14.4a is the language of Article 33.2. And that language is also, with one sort of minor difference, certainly in the English language version, but my friend helpfully points out not necessarily in every language version, it essentially is exactly the same language as Article 21.2a. And so one sees there deliberate decision to, in the context of Article 21.2a, unsurprisingly, given that is essentially concerned with the same principles as apply under Article 33.2, you have the same concept being applied as in Article 33.2. No reason to believe it has any different meaning to Article 33.2. And then that same language being used in Article 14.4a. One also has the point, 2 points really in one sense, because I'm going to come back to that in relation to T. When you go to Article 24, which was obviously, I accept, the provision directly in issue in the context of T, you have different language used. Language used on the approach of the Court of Justice that is intended to be more easily met by the state. And you can tell that's intended to be more easily met by the state because of the fact that the rights in issue are less significant rights. You still retain your status as a refugee. But that language, in one sense, is quite telling because the language used in 24.1 is there needs to be compelling reasons of national security. It's not just any reason of national security, it needs to be a compelling reason. And that's when you come to T. One of the things we haven't seen so far in T is that in T, it was said, ultimately, it's not sufficient you're a member of a terrorist organisation, you need to look at the circumstances in which you're a member of a terrorist organisation. So,
I mean, as you say, compelling reason sounds as if it's a stronger test than just reasonable grounds.
But unsurprisingly, what happens when the European Court of Human Rights, not the European Court of Justice, rather, look at it in T, they focus on the consequences and recognise that the consequences for Article 21, under Article 21, are graver, and so the test isn't as demanding, effectively.
Yes, exactly.
One can see a difference, though. A compelling reason of national security may well be something different to danger to security of a member state.
Well, it may be, my lord, but the point I'm making is that the use of compelling there suggests it's not just any reason. There is a threshold that needs to be crossed. It needs to be a sufficiently powerful reason. And it would be then surprising if there isn't a similar sort of obligation, which is essentially how UNHCR understand the language of Article 33. It would be surprising if you didn't have a similar obligation to consider the circumstances and see if the justification is sufficiently powerful. It may also go to the point that's been made to me before, which is to what extent, in fact, can there be an assessment of the level of danger? Article 24 suggests there can, because one needs to assess essentially how significant the justification is.
Well, forgive me, Article 24 doesn't use the term danger.
No, it uses the word compelling reasons of national security, which suggests...
Yes, compelling reason of national security, not a danger to the security of the member state. It seems to be a completely different test.
But presumably, there has to be some relationship between the status of the individual and those compelling reasons. I mean, it's which is what the European Court... If you come to T, and what T says it's not enough you're a member of a terrorist organisation. One needs to look at the detail, the circumstances in which you remember the nature of that terrorist organisation. So it is focused in one sense on the conduct of the individual and what that says about effectively the justification for denying them the status, which is less powerful, but it's still an important status.
But one can see that there might be a compelling reason of national security to remove somebody's residence permit. But that does not amount to a danger to national security.
That may be right, but my lord, my point about it is that it goes. My fundamental point about it is that the use of compelling in those circumstances implies a value judgment in one sense about the nature of what's in issue.
So
and that's
so does the concept of danger. Danger is a value judgment, isn't it?
Well, that's in one sense my starting point. My point is that if you look at the UNHCR guidance, I'm not sure that danger per se is a value judgment, because what I'm submitting in relation to that, in relation to danger, read in context, this is where the value judgment comes in, the danger has to be, it's not just there is a danger, the danger has to be sufficient to deny the fundamental right in question. And that's where, in my submission, the use of compelling comes in, because it suggests a similar sort of value judgment.
Can I ask you about a different aspect? In T, at paragraph 75, the court contrasts the concept of compelling reasons, contained in Article 24.1, with the concept of, and in quotes, serious reasons, contained in Article 21.2. But that's meant to be a quote, but
well, Lord, that's a different,
wrong, isn't it? Isn't it?
No. That if one reads in context, and I can't find the relevant passage, what it's doing at that stage is it's also comparing, because this is where the similar issues have arise. It's comparing the Free Movement Directive, and it's Article 21 of the Free Movement Directive. Can I, my Lord, would you help me by giving me the page? Because
of T.
T, yes. Sorry, I couldn't.
Yes, it's 617.
Thank you.
And it says, concept of compelling reasons contained in Article 24.1 of Directive 2004/83. Is that the qualification
That's
directive?
the qualification directive, my Lord.
Yeah. Has a broader scope than the concept of serious reasons contained in Article 21.2 of that directive.
That directive being is still the qualification directive, my Lord.
Yeah.
It's not. So sorry, not the qualification directive, the Free Movement Directive, because the Free Movement Directive.
So when it says that directive, it means a different directive.
Because it's the same directive as in that sentence, which is Directive 2004/38, which is the Free Movement Directive.
Where's 38 mentioned?
Sorry, 83, not 38. Sorry, I'm suffering from momentary dyslexia. I got it round the wrong way.
But the qualification directive is 2004/83.
Oh, sorry, my Lord. My Lord's right. What it's referring to in terms of serious reasons, I think, is. I just remember whether.
I mean, the word serious appears, but that's in B, particularly serious crime, which is an entirely different thing. So they're purporting to contrast language, but they're simply misquoting Article 21, aren't they?
Let's have a look again.
Unless I might be completely misunderstanding this, or it may be somewhere else, but it looks very odd to me.
I think that's right, my lord. The reason why. Sorry, the reason why, my lord, just to explain, to slightly mitigate perhaps merely my own misunderstanding of that, if you look at 78, paragraph 78, that's where it refers to the Free Movement Directive, because it talks about public security in the context of 28.3 of 2004-38. So that's where its ultimate conclusions, it does rely to some extent on the Free Movement Directive. That's where I was getting confused, because I could remember the reference to Free Movement Directive in para 78, my lord. Just so that it doesn't appear I'm just making something up.
I'm sure you're not making things up.
Well, hope not. But my lord, I think all I can suggest is that where in para 75, it is simply and I hadn't particularly focused on that. It's using all I can think of is using shorthand in circumstances where but I other than that I can't explain why the European Court.
Fair enough. Thank you.
Can I go back? There's one other thing I wanted to address, though, about the qualification directive, because it featured in one of the friend's submissions, and it is something that SIAC sort of addressed. No, it did address in its reasoning, and that's Article 14.6. Article 14.6 I accept appears to, well, does provide that Article 33 of the Geneva Convention continues to apply even if someone's refugee status has been revoked. One member of the court this morning, I can't remember who it was, asked my learned friend whether domestically, sort of at the material time, or at any time really, the Secretary of State effectively had applied Article 14.6 in the context of someone who's been subject to a revocation decision.
I think it was me.
I can't remember. I couldn't remember. Certainly we've been through. The worst submission for any advocate to make is that there isn't something, because you never know what you don't know.
No.
But we've been through the immigration rules. We can't find anything that preserves that. On the face of it, once, as a matter of domestic law, a revocation decision has been applied, the protection that brings with it is lost. There's no obvious basis upon which one could enforce Article 33 as a matter of domestic law.
Well, except that there's that provision in the, I can't remember which act it is, Section 2. Any provision that in the immigration rules, sorry, it's a negative prohibition. It says you can't have a provision in the immigration rules that introduces a practice that's contrary to the Refugee Convention.
Absolutely, and I was going to make reference to it. We've
Yeah.
cited that. That's right, my lady. But in one sense, the question here ought to be why, and this is consistent with the submission I've already made, which is that as a matter of EU law, it appears a deliberate decision was made in Article 14.4a to adopt the language of Article 33 in both Article 14.4a and Article 21.2a. As a matter of domestic law, in our submission, the obvious way in which Article 33 is safeguarded as a matter of domestic law is by making it clear that you can only revoke if effectively the grounds for refoulement are made good. What my learned friend would need to say is that the immigration rules, despite using that language of Article 33.2 and the same language that's used in the EU provisions, intended that some different test should apply to that applies under Article 33.2 and under Article 21.2. The individual then can have their status as a refugee revoked. If the Secretary of State then seeks to refall, the individual can say, or could have said, pre-Brexit, despite that, I'm entitled to rely on Article 33 still, and now I want this different test applied, even though the language is the same. Post-Brexit, the individual can rely on the provision my lady pointed to, which says essentially the immigration rules have to be interpreted consistent with the Refugee Convention, and so rely on some...
No, it doesn't. That's not what it says. It's a negative prohibition, so it's not about interpretation.
But my point is, sorry, I was shorthanding and probably unhelpfully. My point is that the obvious way in which the protection of Article 33 is present as a matter of domestic law, because it's because of the language used, is you can only revoke if the Article 33.2 test is met, because there's nothing else that effectively gives right, and that's why SITE was in our submission correct in paragraph 178 to say, well, if you've had your status revoked and you have unsuccessfully challenged that on the basis the grounds aren't present, how can you effectively run the same argument?
Well, if you're right, one option would be to apply for judicial review of whichever provision of the immigration rules is said not to introduce a practice which is contrary to the Refugee Convention and say it's ultra vires.
But in one sense, why is that really can that really have been what was intended in circumstances where the rules are plainly intended to comply with the Refugee Convention? They use the language of Article 33.2. They were also intended to reflect EU law. They use the language of Article 14.4a, and that language of Article 14.4a is the same language as used in Article 21.2 and the same language as Article 33. It's a fairly odd approach to use the same language consistently in circumstances where you want a different, lesser test, and that the consequence of that is essentially that the individual who is then subsequently threatened with refoulement has to bring judicial review.
But isn't that inherent in the Court of Justice's reasoning in T?
I'm not sure which passage my lady is referring to in relation to that.
Well, the whole thing, because there's similar language is used in Articles 14 and 21, and what they seem to be saying in T is that you can invoke 14 in circumstances where you might not be able to invoke 21.
I'm not sure I accept that reasoning, that reading of T, my lady, with respect. I mean, if I assume that what my lady is referring to, I mean, to put this in context, because it's worth remembering this, as my learned friend fairly pointed out, at page 594, the Advocate General's opinion, paragraph 83 and 84, paragraph 83, the second sentence, makes it clear that Article 14.4 effectively mirrors 21.2. She then, at para 84, groups Article 14.4 and 21.2 together and compares and contrasts that group of provisions, or those two provisions, with Article 24. So, on the face of it, the Advocate General, whose opinion is approved, albeit in a very different context, seems to say, unsurprising because it's consistent with the language, 14.4 and 21.2 are essentially adopting the same approach, reflecting also the fact that, of course, if you're, and this isn't something I think I've said, but if I have, I apologise for repeating myself. Of course, one of the consequences of Article 14.4 applying is you lose the protection of Article 21.2, because 21.2 only applies to people who are recognised refugees, or it only applies to refugees, rather. The only reference, well, there are two references to Article 14, I think, that you've been referred to. Looking for one of them, because I can't find. One is at para 71. I think that may be the only one. I thought it was the second one, but I may have missed. But that one of them certainly is at para 71. Sorry, the court. Yes, talking about the court's judgment now, which is page 616. And that simply points to the continuing existence, essentially, in the context of someone whose refugee status has been revoked, the continuing existence of a right to rely on Article 33. That's perhaps not surprising because, of course, things may change in relation to Article 33.2. The person may no longer pose a risk.
Am I right in thinking that refugee status is a different concept from being a refugee? I thought we'd originally established that, although the chapters 2 and 3 of the QD are missing from the bundle at the moment.
Being a refugee is defined by Article 1, effectively the provisions that are meant to equate to, I may go slightly wider from memory, but are meant to equate to Article 1 of the Refugee Convention. Refugee status is essentially the recognition of that is a recognition that that definition has been met on the facts of your case. It gives rise to certain rights, including a right to a residence permit, which is where Article 24, for example, comes into play. My lady, just to make good the point I think I just made, if you go back to Article 13, Article 13 defines, obviously, refugee status as someone who qualifies as a refugee in accordance with chapters 2 and 3. It's page 27. So as I understand the system, the way the system operates is an individual who makes an application for refugee status, to be recognised perhaps as a refugee, is granted refugee status if they meet the definition of a refugee.
Yeah.
They then lose that status if, or they then can lose that status, is perhaps a more accurate way of putting it, if the conditions in Article 14.4 are met. And that then...
But they may still be a refugee as defined.
They may still be a refugee as defined.
Right, well that's all I wanted to be clear about. So you accept that there's a distinction between being a refugee as defined in the Refugee Convention and refugee status for the purposes of the QD.
But my point about it is that you then lose various rights. And I go back to the point, if as a matter of EU law, it was intended that this status, that revocation was easier, why adopt the language exactly the same language in Article 21.2 as is adopted in as in 14.4? The clear implication would be but it may assist just while I've got it, because I was just double checking the concession you just made. I don't know whether it's handed up to you this morning, the full version of the qualification directive. I think copies were provided by my friends.
Yeah.
If you go to Article 2,
Yeah.
Article 2C defines a refugee as essentially being someone who's at fear of persecution and to whom Article 12 doesn't apply. Articles 9 and 10, well, in fact, more than that, are really Articles 4 to 10, probably, essentially give further guidance on how to interpret what is meant by refugee. Article 12, which you've seen referenced in that definition, provides for exclusion clauses which reflect Article 1, and my lady will be aware of the exclusion clauses in Article 1 of the Refugee Convention. Going back to Article 2, I don't remember if I took you to this, Article 2D defines refugee as someone who's, refugee status rather, as someone who's been recognised as a refugee.
Yeah.
Article 13 provides that you're granted refugee status if you qualify as a refugee.
Yeah.
Article 14 obviously provides for revocation of that status.
Yeah.
And then Article 21 falls within a chapter entitled Content of International Protection. And my lady will see, and it goes back to, I think, an exchange I had with my lady this morning. That includes things like, obviously there's the residence permit, which is Article 24, but there's also things like travel documents, etc., that obviously reflect the Refugee Convention.
I see that the phrase serious reasons, which was bothering me in T, is found in Article 12, Article 12.2. So it may be that that is where the court got it from.
That may be, sorry.
Muddling up the words of the two articles.
And I was say, apologies for getting the directive wrong, but that's
No,
right.
yes, it's all very positive.
Yeah. But my lady, I come back to the point that although I have to accept, because it's clear, that Article 14.4 is not concerned with refoulement. It is concerned with a concept, and this is one sense where I started from, that isn't actually found in the Refugee Convention. Because all of this about status isn't found there.
Yeah.
You come back to what's the best indication of what it means. And the best indication has to be the language, because for the reasons given in T, essentially, which is that T demonstrates that when the qualification directive was adopted, there was a deliberate decision to use different language if a different threshold was going to be adopted.
The difference about saying that same language, same threshold, is that in Article 14, it's not the last resort.
Well, the last resort that's referred to is not, in one sense, what stage the process is. The last resort is referring to the fact that when the state takes action under Article 21.2, that it has to have ruled out alternatives. And if that is implicit within the use of that language, in my submission, there's no reason why a different approach should be adopted to Article 14.4, because if it was intended that there should be some different threshold incorporated, implied by that language, why use different language? I mean, one other thing that perhaps is relevant in this context is my own friend criticises the approach of SIAC to this, but it comes, in one sense, it's important to think about, well, what is the alternative test? Is the alternative test, and there's no obvious other alternative test other than simply the Secretary of State says there is a danger. Now, given that danger there's obviously a spectrum of dangers, and we all, in one sense, pose a risk because the unpredictable is always possible. But given that even in the context of Article 14, you are denying the individual a whole range of rights, not just the right to the residence permit. It goes back to the submissions I've made a moment ago, taking my lady through the structure of this.
denying them rights, but you're not sending them back to a place where their life will be threatened. So there is a difference.
Well, my lady, what I was trying to do, and probably wasn't expressing it very well, is one way of looking at this is the starting point might be to say that the starting point is Article 24, which is concerned, as the judgment appears to recognise, within sort of the rights that flow from refugee status, or within these three articles, it's concerned with the least significant right. It is simply concerned with the right to a residence permit.
Yeah.
You then come to Article 14, and Article 14, on the face of it, goes beyond that, and it would appear to deny the individual a range of rights: family unity, residence permit, travel document, access to employment. So it's going to be a higher threshold in our submission than Article 24, and that seems to be, in our submission, recognised in the judgment. And that's in particular, if one looks at paragraph 74, I knew there was another reference to Article 14, and I couldn't find it. You look at paragraph 74, of the judgment, which is page 617. You see that 24 is described as being less onerous than revocation of refugee status. 74, 617.
Sorry, I'm in the AG's opinion.
Sorry, it's
Sorry,
617.
yeah, I know. Could you just give me 2 secs? I've
No problem.
gone to the wrong place. Right, got there. Thank you. Sorry, I'm holding you up.
No, it's no problem
Thank
at all.
you very much.
It's quite nice at this time of the afternoon to have a little bit of 617, on the face of it, recognises that the consequences of revocation are more significant than the denial of a residence permit under Article 24(1), and obviously, although obviously less significant than those of reform. Now, on the face of it, that suggests that the test must be higher than that under Article 24(1), because the consequences are greater. If you think about the language of Article 14, that on the face of it is reflected in that language because it's used language that in context is understood to mean a higher test because it's the same language as Article 21. Why would it use the same language? It uses the same language arguably in our submission, or not arguably, it uses the same language because ultimately one of the rights you lose, albeit Article 33 of the Refugee Convention remains in place, one of the rights you lose is the rights under Article 21 too. So it's preventing that indirect loss. And in those circumstances where, and this is where I went back to what is the test, if my learned friend is correct, in those circumstances where revocation has graver consequences than the loss of a residence permit, and in the context of a loss of a residence permit, there is a significant threshold. The language used is the same as Article 33 and the same as Article 21(2), right? there's no basis in our submission for coming up with some intermediate test. It simply certainly can't mean in our submission that any danger is sufficient.
Can I just take you up on this though? You said earlier, I think, in passing,
yes,
we all pose a risk in a sense. I wonder if that's right, because we're not just talking about a risk of some danger. We're talking about, and this again is taken from the UNHCR, acts of a rather serious nature, such that they endanger the constitution, government, territorial integrity, independence, or external peace of the country. Now, I'd say that is inherently a high test. You have to say that this individual endangers the nation.
Well,
so we're not talking here about something which we just say, oh well, this individual has done something, therefore they are a risk, and so therefore we can invoke 14.4. The Secretary of State has to determine that they are a danger to national security. That is the constitution, the government, independence, etc. Seems to me it's a very high test.
well, my Lord, rather, that may go to our ground one in any event, because we obviously say it's a very high test and it has to be, and I'll come on to our respondent's notice in terms of ground one. But my Lord, I'll still come back to the fact, yes, you might come within that test, but if that is a manageable risk, which is ultimately the test site was imposing, how does it justify the application of the reform? How does it justify reform on? And if it doesn't justify reform on, is there any basis for distinguishing between that and Article 14?
Well, my immediate answer to that is it was a manageable risk. They didn't pose a danger.
Well, but my Lord, that's the. But ultimately, well, I agree with that. That was the argument I think I was putting. But that's what SIAC ultimately found in this case was that the Secretary of State hadn't considered manageability, and all SIAC was doing was saying you need to.
Well, that's why it's difficult when if that's an argument being pursued, because we haven't got closed material.
Well, my Lord, in one sense, well, except, and it goes back to I think the question, and this is, I suspect, certainly from our point of view, why we haven't suggested the closed material should be produced. I mean, there is in fact a SASO closed solicitor present if the need to see that material is thought to be appropriate. But my Lord, the point about this is the approach that SIAC.
It's clear from the open judgment that the Secretary of State didn't consider this, and Mr. Kinnear accepts that that's right. So why do we need to look at the closed material?
My lady, that's exactly the point I was going to make in response. Is that ultimately, my Lord, if the approach in Begum is applied, the question is, did the Secretary of State give proper consideration? The Secretary of State didn't, but that means it will go back in one sense to the Secretary of State to consider manageability. So if I'm right about manageability, SIAC was correct to allow the appeal, because on the findings of SIAC, no consideration was given to that. And I agree with my lady that if what was an issue here was SIAC had made its own findings about manageability, then you would need to see the closed material. Absolutely accept that. But as I say, there's no dispute.
Well, I think if it had made its own findings about manageability, there'd be another problem with its judgment.
Well, I'm not suggesting, my lady, that it should have made those findings,
no.
but I am saying, what I am saying about it is that, just answering my Lord's question, that that wasn't the approach of SIAC, and I suppose really partly what I'm also saying is that suppose the precise test that SIAC set out, where it talks about balancing, etc., is wrong, but still fundamentally there needs to be consideration to manageability because revocation needs to be a last resort. SIAC's logic must be that the appeal still needed to be resolved, it needed to be allowed because no consideration had been given to that issue. So the precise details in one sense of SIAC's test doesn't really matter. What matters is that SIAC did recognise, we say correctly, that the language of Article 14.4 means revocation needs to be a last resort. That means there needs to be consideration of alternative measures. It never gave consideration, the Secretary of State never gave consideration to those. So the exact, in terms of what matters most from my client's point of view, which is whether or not the Secretary of State succeeds in this appeal, the exact detail of the test may not matter, because ultimately the question here is, was there a need for the Secretary of State to consider alternative measures on the findings of SIAC in open that haven't been challenged, and the concession made by my learned friend, that was never considered.
So if the appeal were to be dismissed, then the Secretary of State's got to think again, applying the SIAC test, and may or may not make the same decision.
Well, yes, the only qualification I'd say that it may depend on what, in one sense, which bit of the SIAC test. If this court were to conclude that because the language of Article 14.4 means that revocation has to be a last resort, and as a result of that there is a need to consider other measures of management, but the sort of balancing test that SIAC sets out before applying that last resort is wrong, that would still, my point is, it would still need reconsideration, because on the face of it, that last resort was never considered, and because of that, it would still need to go back, albeit applying a slightly different test.
Did SIAC make an order remitting this to the Secretary of State?
I don't think it did, because I'm not sure it has power to do that.
Right.
From memory. My understanding of the way SIAC operates, and my lady, I slightly hesitate before saying this to my lady, because my lady has more experience of SIAC, even though I have got a lot of experience of SIAC, is that, and I think that's right, because I don't think there's any order in this case, the way in which SIAC operates is it delivers a judgment. It is then for the Secretary of State to apply that judgment. I'm also conscious of the fact that there is an appeal about that, albeit in a different context, in the Supreme Court at the moment.
Yeah, because I'm wondering whether the effect of allowing the appeal is simply that the appeal's allowed and that's the end of it.
Well, my lady, except on the Bagan logic, that I don't think can be right, in the sense that, well, allowing it, allowing it can't necessarily be the end of the road, because if the Secretary, on the Bagan approach, what the Secretary of State has, what the SIAC has to consider essentially is public law grounds. Of course, if you normally, in a normal judicial review, if you establish a public law error, that doesn't necessarily mean the decision can't be retaken.
But this is an appeal on the merits. It's not a review. It's
not a review, but if you're applying public law principles, if the Secretary of State adopts a flawed approach, I mean, there's two. Can I put it a different way?
I'm not sure about that. All right. Yes, please put it a different way.
Sorry, just to answer, because I'm.
No, I'm just raising the question. I don't know what the answer is.
Yeah, no,
I just have an instinctive feeling that there is a difference between a statutory review, in which case, if there's an error, a public law error, you remit it to the Secretary of State, and a straightforward appeal. Because if it's a straightforward appeal on the merits, then the appeal's allowed. That's normally the end of it.
But that, once you've got Begum in play, my submission is that can't be right, because.
So you're making this submission against yourself?
Well, we say Begum doesn't apply, but we say that doesn't apply if all that's an issue is whether or not there's an issue of danger. If we win defending the Secretary of State's grounds,
yes,
then we don't, because at that stage there is potentially a more nuanced question to be considered. It may be a lot easier, well, we would accept that the Begum argument is substantially undermined. So the moment we're looking at the situation where the Secretary of State fails, and SIAC was correct essentially to conclude that a ground for allowing the appeal was that the Secretary of State hadn't given proper consideration. Now, that, on the face of it, if, and obviously that's the underlying question in this case, if it is right that the correct question requires consideration to be given to alternatives, to use the shorthand, revocation needs to be the last resort, and the Secretary of State didn't give that consideration to that, then allowing the appeal, given that that's picking up essentially on a public law error by the Secretary of State, can't, it seems to us, prevent the Secretary of State going back and saying, well, I now understand the correct legal basis for taking this decision, I'm going to retake the decision.
Or revoke again.
Well, that's what I mean. That's what I mean. Yes,
Yeah,
but
which is different though, because if the appeal has been allowed and that's the end of this particular outing, if the Secretary of State wants to revoke again, having gone through what SIAC says Secretary of State should have gone through, the Secretary of State would have to revoke on a further occasion.
But I'm not sure in practical terms why that makes very much difference.
Well, it may not. Anyway,
Sorry, mate. Sorry.
I'm just trying to understand what your position was about what the consequence of allowing the appeal is.
Well, our position is, to be clear, but it may not, in one sense, I'm not sure it matters which route one takes to this, is it is open to the Secretary of State to say, whether this is by retaking the first decision or taking a new decision, it is open to the Secretary of State to say, I see that SIAC has allowed my appeal, it concluded I misdirected myself. In light of that, I am going to retake this decision, applying the correct legal test.
One route or another, that must be right. Because suppose, hypothetically, D8 was the most dangerous man you can imagine, and there is no alternative measure which could mitigate or remove that risk. It would just be extraordinary if the Secretary of State were not entitled to take the decision which, applying the correct test, she would obviously have taken first time round.
Yes. Can I just add, though, that obviously, because that is, in one sense, obviously...
I make clear that is hypothetical. We haven't seen the closed material. We don't know...
but in one sense, what you have in relation to that, and that's why I was picking up on it, is the last sentence in paragraph 283, SIAC did consider whether any error was material, because it would have been open, presumably, to SIAC to say, well, there hasn't been consideration of this test, but looking at this, there's only one way in which this could have been answered.
Yes, no, they say that I accept that.
Yes, and that's, in one sense, why I picked that up.
I've just noticed something. Can I just ask you a question about the qualification directive, please, Mr. Savvy?
Yes, certainly.
So, Article 21, 2A, refers to reasonable grounds for considering him or her, blah, blah, blah. Article 14, 4, reasonable grounds for regarding him or her as a danger, so on and so forth. You then go to Article 24. Article 24 uses the language, as we've seen, unless compelling reasons of national security or public order otherwise require. But it says without prejudice to 21.3. If you go back to 21.3, member states may revoke and or refuse to renew or to grant residence permit to a refugee to whom paragraph 2 applies. Now that suggests to me that the drafter of the qualification directive did not consider that the tests in 22.12a and the test in 24.1 were the same.
Well, that's right. I mean, that's in one sense, that's the most obvious thing that is established by T, is that the tests are different. That what we're relying on is the equivalence between the tests in 14 and 21. And of course, thinking about it, which was a point I perhaps should have taken, but didn't, the language of Article 21.3, of course, references the fact that you can revoke refugee status if the language of Article 21.2 applies, suggesting that, given that obviously Article 14 is concerned with revocation, suggesting again that the language is intended to be the same, because effectively Article 21.3 has the same effect as Article 14.4, but But if you go to, I think it's paragraph 75 of T. I mean, it goes back to the submission I think I made some point this afternoon, which is that look at Article 24.
Sorry, which paragraph of T again? Sorry.
It's paragraph 75 of T.
Yeah.
It makes the point in my submission that because the consequences of Article 24 are less,
yeah,
then because the consequences of Article 20, the consequences of loss of rights under Article 24 are less, then it must be the case that 21.2, the 24.1 rather, is not the language used, but this is certainly how I read paragraph 75. The grounds for essentially withdrawing someone's residence permit in 24.1 have to be less than the grounds in 21.2.
Yeah.
Sorry, my lady, am I misunderstanding?
No, it's fine, don't worry.
Right, now, as you know, we need to rise about now.
Yes, sorry.
We've interrupted you quite a lot with our questions, although your answers have been very helpful. We must perhaps let you have a bit more of a clear run tomorrow. But how are you doing in terms of?
I'm very confident that I'm still very confident. I mean, this has taken slightly longer than I anticipated, but I had a discussion with my London friend. I'm still very confident that we will be close to finishing by lunchtime because I've got a lot of what I've covered. I've covered a lot. Can I just say one final thing?
Yes,
I know my lord needs to go because it then avoids me having to come back to tea. I made reference to what the European Court had said in T about the Article 24.1 test, which obviously, as I've just pointed out, is a lower threshold, according to the European Court, than Article 21.2. It's worth just looking at para 99 of the judgment. Remember, this is focused on the court, not the executive, which in one sense is maybe not as, maybe in a worse position to assess these issues, but it makes it clear that it's not enough simply to say someone is a member of a terrorist organisation to deprive them of their residence permit. You need to go beyond that and consider matters such as the extent of their involvement, the sorts of things that go essentially to the extent to which there is a real risk. And that suggests the Court of Justice was satisfied that it is possible to assess relative seriousness, would be perhaps a neutral way of putting it, relative seriousness of the allegations against the individual. And that's in the context of Article 24.1, which, as I say, is less demanding from the state's point of view.
Yes. Right. Very good, thank you. We'll rise now then and resume at 10:30 tomorrow.
Thank you.